Thank you for tuning in to another episode of Paving the Wei with me, Victor Gurr, trainee solicitor and Web3 enthusiast. This episode we are speaking with the artist known as Rilles, who in real life is a copyright attorney known as Kellyn Goler. So of course we will be speaking about copyright and how that is implemented in the worlds of traditional music, generative AI, and of course music NFTs. Of course, you should know that nothing in this podcast should be taken as legal advice or advice of any other kind. I hope you enjoy. Oh, GM Rilles, how are you?
GM, I'm doing well, thanks. How are you doing?
I'm very good, thank you. Really happy to have you on here. I should say, Rilles, of course, your pseudonym, your real name being Kellyn Goler, because I first got to know you as a Web3 musician, being Rilles. I think you popped into a few of my spaces back in the day, and we even had you as a guest on one of those spaces or a few of those spaces to talk about various things to do with Web3. And then I found out that you are also a copyright attorney in the US, as Kellyn Goler, no less.
Which, that's true. Yep. That's
so,
right.
Why don't you introduce yourself a little bit more than I have, and
Sure. Well, I'm happy to be here. Thanks for having me, Victor. My name is Kellyn. I make music under the name Rilles. I also release music under my given name, sort of in a, they're kind of two different genres, which is why I keep them separate. But the stuff I release under my own name is kind of more of a folky acoustic vibe. And then the stuff I release under the Rilles name is more electronic, kind of alternative electronic type stuff. I'm also a lawyer and have been a lawyer for about 10 years now, which is crazy to think about. But for the past few years have been focusing on copyright law and copyright issues.
Wow. Okay. So first off, I didn't, or maybe I did know about the you releasing under your own name and I just forgot. So apologies for that. I'm definitely going to have to check that out as well because I love your stuff under Rilles. You have a fantastic album, Satellite Bird, if I remember correctly.
Yeah, you got it. Thank you.
Nice. I definitely didn't check that out before we started the call. But I think self-described as space pop, is that correct? Or
sure, that works.
Oh, okay. Not self-described then. Okay, but sure.
Sure,
that'll work.
Yeah. I never know exactly how to describe it, but
I'm the same.
Yeah.
Anytime anybody asks, okay, so what's CT20? I'm like, I don't know, it's just heavy. You wouldn't like it. And that seems to work.
Sometimes I say my music is like kind of weird and ambient inspired and that people they stop listening.
We're not the best at promoting ourselves, which there we go. And yes, so a copyright attorney as well. So tell me, we've had conversations like this before, but it's definitely what I want to get back into because you described it so well. Now, my understanding is that copyright law, general intellectual property law, is quite universal. I've been studying it as part of my master's, and I'm also aware of various points, having been sort of releasing music under various names for many, many years. So I'm familiar with, things like Creative Commons, for example. But my understanding is that basically there isn't a hell of a lot of difference when it comes to different jurisdictions in terms of copyright law. But obviously you are coming from a US perspective and you're focusing on copyright rather than any other sort of type of intellectual property, if I'm correct, or am I wrong there?
Nope, that's definitely right with respect to me. The other kinds of intellectual property here, at least, are trademark and patents, and I don't do any of that and don't really know anything about them. I think my sense is that that's probably right, although I know there are differences between jurisdictions in some areas of copyright and some emerging issues in copyright law. Also, something that comes to mind is in the in where sort of the intersection is between copyright law and AI generated works. I think some jurisdictions are taking different approaches as to whether like an AI tool can create a copyrighted work or can be the author or owner of a copyright. Those kinds of questions I think have been approached differently in different jurisdictions. But I am based in the United States, and so I really only know some stuff about U.S. copyright law. I'm pretty sure that it's very similar between the U.S. and the U.K., but you can check me there as we get into it.
Well, I'll certainly do my best, as I say, studying it at the moment. And I'd love to know more from our conversation. So, as if I had come into this completely blind, give me a rough overview of what copyright is.
Sure. So, copyright is a type of intellectual property that protects original creative works when those works are put in the way that the law describes this is a tangible form of expression. But basically, if you are the creator of a work, when your work kind of comes into being tangibly, then you are protected under copyright. And copyright can be thought of as a sort of a bundle of exclusive rights that protect what you can do with that work and what others can and can't do with that work. So, for example, a rights owner under copyright has the exclusive rights to distribute their work or sell it, make copies of it, perform it publicly. Those are some examples. And as the rights owner, you can restrict others from doing those things because those are your exclusive rights. You can also give others permission to do those things under a license agreement or some other kind of legal contract. But essentially, copyright protects creative works and function to the benefit of the authors of those works or the creators of those works in terms of protecting what others can't do. That's a pretty simple way of looking at it, but I think that's roughly right. Okay,
so one of the things that did strike me, actually, that is different about US copyright is that the division between registered and unregistered. From memory, in UK copyright law, or I should say English and Welsh copyright law, copyright is sort of given as an automatic right. I think there are forms of registrable copyright, but essentially they're not. Most things are protected sort of from inception, really, or from creation. But there is quite a big difference between registered and unregistered, as far as I understand, in the US. Is there anything you can give me on that?
Well, what you were saying about copyright being sort of automatic is also true in the U.S. If you were to make a song, let's say, or a recorded song, as soon as that recording, let's say, is finished, or you have something down, you have copyright protection for it, but there are benefits to registering the work with the U.S. Copyright Office, which is the agency under our law that kind of administers and oversees copyright at a broad level, including the right to sue for infringement. You can do if you've registered the copyright. I think you can't sue for infringement in federal court if you haven't registered the copyrights. I think there are some other benefits, but overall, the protection technically is automatic as soon as the work is fixed in a quote unquote tangible form of expression.
Okay. So I think you said that you had heard maybe some, I'm not sure if you listened to the full episode, but with Sound of Fractures, our good friend Jamie. And one of the things that came up was really incredible that it did come up, actually, because I couldn't remember if it was more of an urban myth. But this idea some decades ago that if you intended to kind of quasi-register your copyright in the UK, you would create your... Let's bring it back to music. So you would create your song, you would somehow record that onto some medium, so be it tape, CD, whatever, and you would... I can't believe this is a thing. You would post it to yourself, and never open that
right.
And I mean, maybe I'm missing something here, but it just sounds like the most ridiculous. I can't actually think of what that achieves, but maybe you're going to turn me around and say that works.
I've heard the same thing. I mean, I've definitely heard the same thing over on this side of the ocean. At the same time, because copyright protection is automatic, it's kind of unnecessary and you don't really need to do it. And I'm not sure what it gets you overall. I mean, as I mentioned, if you wanted to sue for infringement of your work, let's say somebody else passes your work off as their own and you're saying, like, that's not right. I'm going to sue. I'm going to bring a lawsuit. Then if your work is registered, which it needs to be in order to bring that lawsuit, I guess if you have a mailed copy, you could potentially argue that's like evidence that it was yours first. But other than that, I don't know that gets you any greater protection than you already have under the law. But we have like the same kind of idea or myth exists here. I should look into it and figure out where it came from, or maybe it was. Yeah, I
have a feeling it won't take you long to get your answer, but let me know.
I will. I'll report back.
So obviously you're a musician as well, but my understanding is that you also practice. So not just in particular a copyright attorney, but you practice in a more niche area, which is music. Is that correct?
Yeah, more or less. I just recently left a law firm, and our clients were largely, the clients that I worked for were largely music companies who were, who had copyright related concerns, and they would come to us for those things, whether that was litigation or otherwise. It tended to be litigation, but not necessarily so. So that's roughly right. I think there are the like kind of quintessential idea of a music lawyer representing artists or writing contracts or negotiating deals. I didn't do any of that, so I don't have any of that kind of expertise, but I think I have kind of a big picture understanding of the way the music industry works and the way that copyright law kind of plays into that.
I'm interested to know what your methods were or your style. Just out of curiosity, were you quite a cooperative litigator, or are you more aggressive, would you say?
Oh, that's a really interesting question. I think that there's a time and a place to be aggressive, but I'm not a very aggressive person usually in like my personality or in my practice, I guess. But some of the best litigators, at least in our system in the US, like can be quite loud and aggressive. It can be very effective depending on the context. If you're presenting a case to a jury, or if if the situation calls for it, that can be really good. I think overall I tend to be like a more calm and serious, or maybe like a chill is not the best adjective probably in this context, but like that's kind of how I see myself. But I just, sometimes I feel like that can also play to somebody's strengths, to not necessarily get overly loud or aggressive, but instead to kind of set the tone. And if that tone is calmer, it can work in a different way to persuade people.
Yeah. I agree. For sure.
I have a question. This is sort of a side question, but since you're studying law, in the courts in the UK, are lawyers also aggressive, or does there tend to be more decorum? I know you guys. There are a lot of rules, and there are some outfits that you have to wear, but I don't think I've ever seen like a proceeding to know.
So that's in terms. I want to go back to the outfits, because actually that sort of attorney in the US is quite a different system to how we work in England and Wales, because actually we basically kind of have a 2-tier system. So I'm training, at the point of recording, I'm training to be what's known as a solicitor. And a solicitor is, generally speaking, it's a little more open these days, but generally speaking, is the initial sort of client. It's the person that the client goes to first. The solicitor is the one that sort of gets down to the nitty gritty of, what the matters of the issue are, what documents are needed for disclosure, and then what needs to be put if it goes to court and it goes to one of the higher courts, because not all solicitors have what's known as rights of audience. So I, for example, even as a practicing solicitor, may not be able to stand in front of a judge in the Supreme Court or the Court of Appeal, because I would not have the right to do so. And that right is reserved for a profession of people that are known as barristers, who do have this right, and they tend to be far more knowledgeable in things like case law and statute about more niche areas of law. So solicitors, I am speaking so generally here, but
sure.
But solicitors tend to have a broader knowledge of the law, whereas barristers will have a far more sort of pinpoint knowledge, and they can argue that on behalf of their client. And yes, they are often required to wear a costume, let's say, or perhaps uniform is a better term. But yes, they do often end up wearing the gown and the wig, depending on the court that they are in. Obviously, there are some courts where it's not necessary, or in fact is seen as not a particularly good idea. For example, if you're in a child case, it just doesn't make any sense, because you want to make the children feel comfortable in their surroundings. So you don't want to be dressing up really and looking all, well, what the child may see as pompous. But yeah, there is a division there, and I have no idea how we got onto that topic.
All good.
Now we've got this broad overview of copyright law, at least in the US. Is music not just sort of like an area of industry within copyright that sort of copyright can relate to, or is there anything different about music copyright in particular?
That's an interesting question. I think that, you know, the music industry, or the music business as we understand it, is quite complex, with a lot of different kinds of players, you know, that are all sort of doing different things in the world of getting music out to the people. I think a lot of those things and a lot of the revenue streams in the music industry are traceable directly to what is coming from the copyright law. So, for example, in the US, and I think in the UK, but again, check me, there are separate copyright protections for sound recordings and musical composition. So in that distinction, you can think the difference between recording artists and record labels who sometimes own the quote unquote master recordings that an artist will put together on the one hand, and then on the other hand, songwriters who compose the songs, and then the publishers who maybe own the compositions and, you know, represent those interests. And there are different revenue streams between the sound recordings and the compositions. And, you know, record labels and publishers will be doing different things because they're handling different products, basically. And then there are also, you know, other kind of actors or players in the music industry, like the, you know, performing rights organizations or collection societies that are representing songwriters and publishers and collecting certain royalties that are available under law. And, you know, it gets complex if you look closely. But, you know, I think a lot of the business is coming from protection and kind of, I mean, people use this word exploitation of copyright, or like exploitation of rights, not in like a derogatory way, but just in, you know, in figuring out how to best kind of exercise, or, you know, maybe exploit is the best word, but best exercise those rights in the real world. Like, yeah.
Exploit does have negative connotations, but it doesn't. Yeah, I know your meaning. It's sort of the best way of utilizing it in order to get the most out of it.
Right. Yeah.
Did you say that there was a difference between performance copyright and was it master rights?
So a recording artist may or may not have a contract with a record label. And if an artist does have a contract with a record label, I think generally speaking, the record label usually, but not always, owns what are called the master recordings. And so, that's why you might have a label that's going out and, interfacing with folks who want to use that recording in some context in the wider world rather than the recording artist himself.
Okay. Yeah.
Yeah.
Okay. So I can certainly see sort of how this has come about and why, because there's a lot of people that get involved with these sorts of things, and obviously clearly lots of different rights want to be protected for lots of different people, but for one product that it will be at the end of the day, a song or whatever, that must get quite tricky, sort of keeping everybody happy, keeping everybody on board. What can you speak of in terms of your experiences? What recurrent themes do you see in the cases that you've had to fight?
That's an interesting question too. Recurrent themes. I don't know that there's anything that comes out of even, to the extent I can talk about the litigation work that I've done. I think it's a broader idea that's not necessarily precisely drawn from my work itself, but my sense in the world, and you might get a sense of this too, because, I think this is very true in the arena of Web3. But I think the recurrent theme that I see is just that a lot of people don't understand copyright. You could say that about a lot of laws and a lot of, what's going on in the world of intellectual property more broadly. But I think that in music, even for people who are making music themselves or who might be working, in and around the world, might not have an understanding of kind of the legal framework that has shaped how this industry has developed and what enables different kinds of people and companies to do what it is that they're doing. And that lack of understanding, I'll say, I think it emboldens people to act when maybe they should first try to learn. But it's hard because, you don't know what you don't know. And I think overall it's hard to expect that people know the ins and outs of any kind of, tough legal framework or issue. But, copyright law is complicated, and there are many, many kind of what I would consider like open questions or open issues or things that are untested. And I think it's hard to expect people to know that, but I think people who don't know those things often then, strictly speaking, can run afoul of the copyright law without necessarily intending to do so.
Yeah, I get that. That's I think the law all over, really. It's an incredibly difficult thing to understand, but yet we all have to adhere to it. So one of those ongoing issues, and always will be. You mentioned earlier, you sort of spoke a little bit about AI generated works. Of course, most prominently, we've seen visual art in sort of the media recently, where people are writing a sentence into something like Stable Diffusion or Midjourney or DALL-E or whatever, and it is producing pictures for them. Now, I have to say, I'm a fan. I love AI art. I'm perhaps seeing a little bit too much of it recently, and you can certainly tell which programs people have used because there is a particular style, which is interesting actually when you say perhaps what or who holds the copyright, seeing as there are these sort of recurrent themes, I think. But how does copyright, into your mind, come into this AI generated art field?
Yeah, I think in a number of different ways. Touching on what we were talking about before, and this exact kind of concept of a text-based prompt that leads to image generation, there have been, I think, some more recent, I don't know if it's technically a decision. The U.S. Copyright Office recently issued a policy statement and a decision in a particular instance about copyrightability of AI-generated work. And I think that the current perspective of the U.S. Copyright Office, which again is that agency that's going to oversee the administration of copyright here in the States, is that, let's give Midjourney as an example. An image generated using Midjourney is not copyrightable because as the Copyright Office sees it, there's a requirement under the law of human authorship. And I think this policy statement is available online, and there's like more discussion, more detail that folks can look into if they're really interested. But their perspective is that there needs to be human authorship, and there isn't if the AI tool is itself generating the image, even if there's a human on the other end of it putting in a text prompt.
Wow.
That's kind of where things are currently, and who knows where things will go from here. This isn't the decision of a court, or it's also not like a law, I'm using that in air quotes, or even a rule, and I'm using that also in air quotes, and like the legal connotation of those terms. So it could change over time. But right now, that is the perspective. That's the approach that the Copyright Office in the U.S. is taking in the image world.
And what I'd love to go back to that perspective, actually, because I'm sure everybody could have a different thought on that. I certainly do. But what power does the Copyright Office have then? If it's not law, it's really what? It just sounds like what? Guidelines?
I mean, it's guidance, and I would also say it's the official guidance of the agency that is going to approve or reject a particular copyright registration. So this issue has come up in the context of an artist, for example. There's an artist in New York named Chris Casanova who wanted to register for copyright protection a comic book that included images that she used Midjourney to generate, along with, the story that she wrote. And she did manipulate the Midjourney images further a little bit with Photoshop, I think. And if you're familiar with how these tools work, that there's some refining that you can do, create variations of the images that the tool creates, that kind of thing. But the Copyright Office said while her comic book is worthy of protection and it was registered, so it's, there's a copyright for the comic book, the individual images themselves, because they were generated by Midjourney in the Copyright Office's, view, those images would not be copyrightable. Or I think that's the best way to look at it. But, this is, I think both that particular artist and then maybe other artists in and around the AI world are kind of looking at these as sort of test cases, and they're intentionally moving forward now, trying to push the boundaries of that and see, does that approach stand in every instance? Is there anything that artists or creators can do to sort of change that approach? It is, I will say, the Copyright Office has said this is like a case-by-case inquiry. So it's not like they're issuing kind of a blanket approach in every single instance when AI is involved. But when AI is involved, they're going to be taking a closer look.
See, I get that. But again, going back to sort of the power that the Copyright Office does or does not have, I mean, clearly they can, at least at first instance, choose whether something is registrable or as copyrightable or not.
Yep.
There must be, I would have thought, some kind of, I mean, like you say, the artist is perhaps trying to find the loopholes, trying to game the system to see what may or may not work. But that is only going to be in the eyes of the Copyright Office. I mean, what?
Sure. There's other processes. So, for example, there are various levels of appeal for a particular decision, and then I think you could appeal the decision of the whatever it's, I think the Copyright Office Review Board, I'm not sure what the tribunal is called, but to a federal court, and then just follow that process until eventually there's like the idea, I think, would be, if necessary, a case could go before a federal judge at whatever level and get a more final, kind of decision. Like there is oversight, but
yeah, I'd say depending then on how long the Copyright Office takes this stance, we will definitely see something like that, because I mean, it's certainly, to my opinion, and I'm not. I need to catch up on what our current government's view is on AI art, but my view is that there is an element of human authorship in that is you don't always, I mean, you'll know this, creating music, we don't always know what's going to come out. Sometimes it can be the machine's work. We fiddle about with something and it surprises us, and it's intriguing and we enjoy it and we stick with it. So you could argue that many elements of the work that we do is machine made. But yet, sure, at the end of the day, under the law, it's not.
Right.
So
yeah, I think there's a case in federal court right now in which I think he's a scientist and an entrepreneur. I think he has his own image generator tool that he himself created, but that's not the point. He's testing the boundaries of this question in federal court because the Copyright Office denied his registration application, and so he's appealed that at every level, and we'll see what the federal judge says in that case. But I totally hear your thoughts, and these kind of happy accidents, I think, exist and happen in tons of different kinds of creative processes. And we'll just have to see where these things shake out. Yeah,
absolutely. I'll be keeping a keen eye. One of the things that I read about recently was that I think Getty Images is taking Stable Diffusion. I believe it's Stable Diffusion, the people that made it, to court because a copyright issue. Stable Diffusion has been scraping images, the argument is that Stable Diffusion has been scraping images, some of which are watermarked Getty images, which they hold the copyright for. I don't know if you could give me an opinion, but perhaps maybe a perspective on how you think that works. I mean, again, if I take it from a purely inspirational perspective, now I'm not going to ever create any art purely from nothing. Everything I do will in some way be inspired, but there is a difference when you create something akin to a collage, for example. And of course, a lot of the people who are against AI art in general often see it as a form of making a collage artwork, in that it just sort of slams other people's art together in this mismatch thing that may or may not be original. So do you think Getty, if their argument is correct, they have anything to stand on? Do you think Stable Diffusion should be perhaps relying more on a licensed pool of art to scrape from, or whether there's no issue at all in taking things from Google Images, for example?
Yeah, can I give you an opinion, strictly speaking? I don't know, but I will say, like, short of that, I will spell out the sort of issue here maybe in slightly different terms as I see it. But if a particular tool, an AI tool or model or software, whatever, is using unlicensed, copyrighted works in its training data, there seems to me to be a copyright issue at that step of the process. And I'm aware of the Getty Images case. I don't know too much about the facts, and I will also confess that while I too enjoy these image tools, I also don't really fully understand the diffusion model, technologically speaking. So with that as like a caveat, I see the copyright issue. To me, it's pretty loud and clear. I don't really know, where that will shake out under the law or in court. I think it will be fact specific, and it'll depend on kind of like what happens in the litigation and what facts come to light as that case progresses. But I certainly see the issue, and I don't think it is a small one. I also don't know where exactly it leads. One thing that comes to mind, I don't know if Stability AI has made this argument or will, but I think that I've heard in sort of the online discussions about these kinds of issues, the concept of fair use. I don't know if that exists over in the UK.
There is it's called something else, but yes, it does exist.
Yeah. And right now, fair use is kind of in flux. There are some pretty high profile cases happening as we speak, and some open questions about fair use. I don't know if this would qualify as fair use, but frankly, I'm not a fair use expert, so you'd have to ask somebody who is. I think in every instance, the safest thing to do if you're going to use copyrighted works, in my view, my personal view, is to get permission to do so, which would be, for example, a license agreement. But things are moving, things move fast, and this will ultimately be resolved, and we'll have some guideposts once this case is resolved, and once these. I think there are some other cases that are a little bit similar, involving different kinds of works, or different kinds of copyrighted stuff. But I think when we move forward in time and these cases progress, there will be some more guideposts that will make these issues a little bit clearer.
Certainly, yeah. At least in the US, anyway.
Right.
I mean, this. I wonder. Again, I'll have to sort of get myself up to speed on the position that the UK government has on AI artwork. I know, generally speaking, that the position on AI is very strong. The UK government is very much trying to push innovation in the sector. Of course, ever since Brexit, we're just trying to find money in places wherever we can. So, but when it comes to AI art, I'm not entirely sure. So, but if it would fall in line with the current perspective on AI in general, we may end up across the pond be coming up with completely different decisions as to that. So it'd be very interesting to keep an eye on, where definitely. We've sort of, I'd say up to this point, been quite sort of in line with each other, but we shall see.
We shall see.
And how then, I don't know if you managed to get a chance to listen to the second episode I had with Ilya Tolchanov, but he is creating or co-creating a music AI. I imagine that many of the same issues will arise, where you've got things like Google LM, which, as far as I understand it from my conversation with Ilya, works very much like your Midjourneys, like your Stable Diffusions, in that it takes a work, but in this case music rather than visual art. It is able to generate something based on already existing artwork, music, art pieces, whatever. Whereas Ilya's Polymuse does everything from the ground up, so there is no chance of doing that where it is not licensed to do so. What sort of issues might you see arising in terms of the music world, in terms of generative AI? Do you think it would be just very much the same, or do you think we're going to see anything different at all?
I will confess I haven't listened to that episode yet, but certainly
get away.
Interesting. I know. I will boot it up after we hop off. Interesting to think about a tool that is so. Are you saying that there's no big training data set of existing stuff?
No, it's okay. So I'm giving you my best description of it. Ilya would be able to tell you much better. But the AI has been taught music theory, and it is then the only sort of copyrightable element that I'm aware of is what they call sound worlds. So it's basically a bunch of MIDI files, stems, synths, or whatever that an artist or a group of artists has created for Polymuse to use.
Yeah. Yeah, I mean, at a glance, like on that description, I think that would sort of sidestep the kind of issues that we were talking about, with like, this issue of training data if it includes unlicensed copyrighted stuff. In the music world generally, I think the same kind of issues would probably come up. It kind of remains to be seen. I feel like the image tools are much more prevalent, or at least in kind of the zeitgeist today. The image tools and the large language models are sort of where people are looking. But I would expect that over time, as these music tools become more widely used and more widely developed, that like we will get the same kinds of discussions and test cases to try to figure out kind of where the boundaries are and should be going forward.
Yes, it'll be very interesting to see.
Yeah.
So we got to know each other, as I explained at the beginning, through kind of the Web3 side of things. I'd say, I mean, I don't know about your background, but certainly CT20 was kind of born almost into the Web3 world. Certainly that's where I've put, I'd say 90% of my marketing effort. And of course, as Reels, you have minted at least on Catalog, which amazing, by the way. Congratulations.
Thank you.
And you're also going to be minting under Jamie's air quotes label, Wild Awake. Is there anywhere else that you've minted actually while we're on this? Zora, you were on Zora as well.
Yes.
You used, yeah. What was
That's
that?
it. Well, it's two different things, but as you know, using again music NFT and sort of air quotes. I minted a song as an NFT on Zora as an addition. So, Catalog is a one-of-one platform, and I think Jamie's kind of label idea would be edition based, but that's definitely a him question, not a me question. And then the song I put on Zora is an edition, a small edition, but
So you're clearly very comfortable with the Web3 scene, I guess.
Sure.
And as I say, that's how we were certainly introduced to each other. So I remember speaking to you about... That's right, because I was trying to persuade you to come on to utilize the Hago NFT utilization. And you were concerned about what song you could use, because if I remember correctly, and correct me if I'm wrong, some of certainly the track that you were considering minting used samples from a service called, was it Splice?
Yeah. So it's. Oh, sorry. Go ahead.
No.
Didn't mean to cut you off.
No, it's fine. I mean, I just from memory, you were saying that you were not entirely sure whether the license agreement that you have signed up to with Splice would actually allow you to mint anything using their samples as an NFT, which to me is just so backward thinking, but is certainly, I would say, perhaps up to them if you're using it. I mean, what's the update on that?
Yeah, I really should have looked into this before we hopped on the line. That's right. And back in the fall or whenever we were talking about this, but I remember there was like sort of a moment when people were talking about this last fall. Splice had issued kind of an update to their sort of like guidance to their service that said explicitly, like, you can't use our samples in any NFT. Like, just, blanket kind of don't include us in any NFT. And, there was some criticism of that approach, and some other people who were like, well, NFTs overall seem like a terrible idea, and so this seems like a good approach. As you know, people have very strong opinions about NFTs and Web3, and not for no reason. So give them that for sure. I don't know what the current status of that policy is, but yeah, I mean, I think this kind of brings up kind of my broader thoughts on Web3, and it's the intersection, between copyright law and other laws and Web3. But just to take sort of a step back, I look at Web3 as another kind of avenue of distribution, or sort of another format through which you can release music, and also another world in which you can build a community and find people who are interested in your work or support you, or people that you want to support who are interested in new technologies and kind of new ways of doing things. And at the same time, I don't think there's any reason to believe that copyright law would not apply in the context of Web3. And so from my perspective, the usual rules around licensing and permissions would, to me, seem to apply there as much as it would apply to, quote unquote, Web 2 or real life, or however you want to look at kind of the distinction between Web3 and everything else.
Oh, but hold on for a second there. Don't you understand that there aren't any rules in the blockchain? There's no law. Right. That's what they keep saying.
That is what they keep saying, but this is maybe my unpopular opinion, but I don't think that perspective will win the day.
Yes,
we'll see.
I agree entirely. I think it's, do you know what? I am all for kind of loosening the knot, as it were, if that's the correct phrase, to allow for innovation. But this mentality that there are no rules in Web3 whatsoever, that because it's a new technology and nobody knows anything about it, that people can just do what they like. And I think that's absolutely insane. I mean, perhaps we don't know exactly how all existing laws will be implemented, but that's not to say that they aren't implemented. I mean, is there anything, certainly to my mind, one of the things that was so prevalent, I'd say a year or so ago, was moving away from music for a moment, because it was so much more obvious in the visual arts world, if we can call it arts, because if I talk about things like the Bored Apes, which I can understand why people like them, but in terms of the actual artwork, I can't say I'm a fan. But of course, the idea being with the apes is that the one that you own, you suddenly are given access to an amount of intellectual property rights usage. Certainly that's how I understood it, and suddenly, because of the popularity of the apes, a lot of other projects followed suit and decided that they would also give IP away, because every single image of these 10,000 generated images is supposed to be unique. Then why not allow the holder some kind of usage with that unique picture? But my understanding is that it's not, legally speaking, that easy just to give away usage rights. At least so licensing has to be done party to party. And if it's not done like that, so the licensor giving the licensee a right to use particular aspects of the art in a particular way, then that right hasn't been granted at all. And if the licensee believes that they have these rights, even if the licensor has said, or who could be the licensor, has said, yeah, sure, go on, do what you like, that doesn't necessarily mean that the person holding the NFT, when they sell that NFT on, is then able to pass those rights on to the next holder, for example, because they haven't got the legal right to do that themselves. And one of the Oh no, it's gone from my head now. But let's focus on that point for a start. That was it. Creative Commons. The only other way I can think of that, so Moonbirds picked this up. They came out around the time where suddenly people were seeing so many issues with giving away IP, and some people were realizing that actually it hadn't been working. And so Moonbirds decided that for their PFP project, they would release it under a Creative Commons license, specifically CC0, which meant that actually the IP rights were given away. But of course, my understanding, and you may want to correct me here, is that by using Creative Commons, it's an open license. So you don't necessarily need to have bought into the product to be able to use the intellectual property of the product. And that is going to be even messier, in my opinion, if somebody who has not spent any money on the founding company whatsoever is suddenly able to use their property in whatever way they like. My goodness. I mean, what is going on here?
I'm going to be honest, I don't really know. I will say I'm certainly not... I'm not an expert on Creative Commons, even a little bit. I'm, at the most basic understanding of those licenses. Yeah, I mean, I've certainly heard about these issues as you sort of explain them. I wish I had anything of substance to contribute, but I really don't know much about truly how these things work or what will happen or, who has what rights. But it certainly seems complex and messy even. And yeah.
Sorry about that. It's just honestly something that's fascinates me. It really is. It's something that's fascinated me. And I have to say, I think it's just because it's so convoluted and because people believe that they can do what they like. It's throwing up some really interesting cases. But how you were saying earlier that you do see a lot of copyright law being implemented by Web3 projects. In what sort of instances have you seen where it may have perhaps been done properly, or in fact, on the other side of things, done improperly, particularly in terms of music? Are there any particular projects that spring to mind?
I don't know. I don't actually know if I have any examples or any thoughts about that. I mean, I think, or even, I don't know if I know enough about them to make that kind of a call.
That's fair.
I think, I think overall it's in everybody's best interest if people who create projects or, create companies working in this space, learn a little bit about copyright law or learn a lot about copyright law and how it works and what it means for any particular product. Sorry, that was a bit of a non-answer, but
well, I get you. I mean, I think what you're really getting at here is what we really love to say is that people really should be looking to get legal representation. Would you not agree?
I mean, yeah, it's sure. Yeah. I think part of the ethos in Web3 and just in the tech world in general is, things are moving fast and we tend to be very interested in technological advances and in new stuff, new tech, new products, new things, right? And the law is like notoriously slow and it's slow to catch up. But, these structures are in place. And like you said, if you have questions, definitely consult an attorney or somebody who's, licensed and can give you actual legal advice because these are super interesting issues. And yeah, I'm just really interested to see where they will shake out over time.
Me too. So I want to go back to your music just for a second. Where will people find you to listen to that awesome album, Satellite Bird?
Yeah, well, it's available on all streaming services and that we mentioned those Web3 releases, but frankly, it's on all the big ones. It's on all the big ones and it's on all the small ones. So feel free to listen wherever you prefer to listen.
Amazing. And I have done many, many times. That's certainly, and one of your tracks has actually made the CT20 producer public playlist of favorite tracks.
Thank you. I gotta subscribe to that.
You need Tidal. So if you've got that, no problem. But if you don't, it's nowhere else.
Okay.
But there we go. Well, thank you very, very much for joining me today. It's been an absolute pleasure. I've always enjoyed having these discussions with you in the past, and so it's a great joy to have yet another one. I feel very privileged.
Same here. Yeah. Thank you for having me. It's been great.
Thank you. No, absolutely my pleasure. We'll speak to you soon. Thank you again for tuning in. For more content like this, you can search for me on socials under Victor Gurr, that's Gurr, and of course via your favourite podcast app. The music in this episode was composed by CT20.
Till it got old.